About 3 years ago, the province then launched a constitutional challenge. We argued that the federal government overstepped its jurisdiction by imposing this carbon tax on Saskatchewan residents and Canadians in general. Ontario and Alberta, they launched their own constitutional challenges. And our case was heard in the Saskatchewan Court of Appeal, and after a split decision in Saskatchewan and in Ontario and a ruling against the federal government in Alberta, the case then went on to the Supreme Court of Canada. Today, the Supreme Court has released its judgment. The court has ruled that the federal government does have the constitutional authority to impose a carbon tax on the hardworking people that I represent in this province of Saskatchewan. While today's decision does effectively end our legal avenues as a province, it does not end our opposition to this costly and ineffective tax. And just because Prime Minister Justin Trudeau has the legal right to impose a carbon tax, I would say that it doesn't mean that he should. The Supreme Court decision does not change our core conviction that the federal carbon tax is bad environmental policy, it's bad economic policy, and it just simply is wrong. It's simply wrong to force Saskatchewan families to pay a tax on fuel that they may use to heat their homes or to drive their kids to school. It's simply wrong for the federal government to impose a tax that will increase the cost of virtually everything that we purchase, from groceries to clothes to cars. And it's simply wrong to punish Saskatchewan companies who employ Saskatchewan people whose competitors operating in other jurisdictions are all too often operating without the imposed carbon tax.